All right, looks like we're live. Hey, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup, this time for April 8th, Eclipse Day of 2024.
I am waiting. We are like 1 hour away. I'm here with my glasses. I'm not even looking. Wait, for us, it's totally cloudy outside. I don't know what yours is like, but
It's a little bit cloudy, but I'm not changing my day because of some
no,
eclipse. So,
no. Well, I gotta tell you, today is some interesting stuff. This definitely leads some of the you can't make this stuff up. So let's get right into it. Let's head to Kansas City, Missouri. I'm not sure which is funnier, the facts or the investigation, but here's what we got. We're in Kansas City, Missouri. We have a firefighter who's facing felony charges for reportedly urinating on a female colleague's personal property at the firehouse. Now that's bad enough, but so she walks in September of 23. She notices a strange smell. She looks at her in a closet, sees her possessions are wet. She somehow believes that they were urinated on. So that's incredible as it is. But what's more interesting is that the police test it, do a DNA test on the urine, and prove or believe that it came from this guy who's now facing felony charges. I didn't know you could. I mean, I knew you could, but my God, who would DNA test urine for this? But they did. And this guy who's charged, not convicted, charged, has a road rage incident conviction in 2019, which resulted in a guilty plea. And, so maybe he's got an anger issue or a bladder issue. I have no idea which.
I would like to think that this is an isolated case. This is the first time something like this has happened in the fire service, but guess what? It is not. And I have a category of cases, urinated cases. And I know and I've got somewhere, I just ran the numbers, somewhere over 100 cases involving firefighters being disciplined for
Wow.
urinating in places they shouldn't. So this is I was just on the phone with a psychologist, and we actually discussed this issue, and I'm like, what do you think is going on? And she was like, well, I'm not sure, but there's something going on.
Maybe the
Um,
clothes were on fire. Let's give it the benefit of the doubt. It's possible, or the clothes were on fire and he couldn't get to a hose, so
yeah,
no,
yeah.
huh?
You're a good defense attorney, but I think there's something deeper going on. And but reality wise, okay, even we've had soldiers urinating on the corpses of
Sure.
dead whether they were soldiers or civilians, but that's happened. I think it's a sign of disrespect,
Oh God, yes.
and it's socially unacceptable, and certainly should not be happening. But my guess is, the folks that would engage in this kind of thing, this is not the only time they've engaged in inappropriate behavior. You don't have someone who's going along, you know, conforming their behavior to the norms of society, and then all of a sudden one day they do something like this. So that's
Right.
my guess. And I don't know about this particular gentleman. I have no idea, but I'm a big believer in discipline, and that, we recognize when we're having a problem with a particular individual. We try to address it long before we end up having to deal with something outrageous like this. So,
Yeah, this
but
this is insane. This
yeah,
this truly is
yeah,
insane. Despite I laugh, I obviously feel badly for the woman who this happened to.
yeah,
It's straight out. Well, look, it's a felony. They
yeah,
they got it. So, um, anyway, okay. Well, let's head to Alaska. That's
yeah.
I don't know how to leave that one behind, but let's head to Alaska.
We're better off
This,
leaving it behind. Let's
yeah.
close the door on that one, and we'll wait for the next urinating case to come up, because absolutely
and
no doubt it will.
And if you're watching, there's no reason to prove Curt right. Just let it go. Well, don't let it go, but let it be. Okay. So Alaska. So here we have what I would say a textbook FLSA fire chief overtime complaint. It's a pretty good first year law school type, FLSA type thing. So we have the fire chief of the Salcha Fire and Rescue Inc. So it's a volunteer entity, I believe, and it's a corporation. So anyway, he files suit in the U.S. District Court. He's seeking compensation for overtime. He claims, listen, I was fire chief, but I'm not entitled to the executive, right? There's three, but the one that normally fits the fire chief is the executive exemption. And the executive exemption has rules, basically job descriptions and powers that you have to be able to meet. He basically says, or does say, listen, my primary duty is to respond to calls. My next primary duty is to do training. And after that, I have some other managerial level. But he says, I report to the board of directors. I report to the president. He is not the top of the organization. He makes light of or doesn't mention much of administrative duties, only other than to say they're tertiary response duties. So I think you would agree, if the facts are true, as he alleges, this is just a lawsuit, if they're true as he alleges, he probably has a pretty good case.
Yeah, and the burden, believe it or not, here is going to be on the fire department. Once someone establishes that they're, number one, an employee, number two, of an entity to which the FLSA applies, and it's be very, very rare that the FLSA would not apply. So basically that's a given. So he's established he's an employee. So now it's going to be up to the department to show that more than likely the executive exemption applies. And, that's going to require a showing of a couple of things. But, there's a salary test and a duties test. And I didn't see in the complaint any sort of indication that he was paid a salary. So that's going to be the first thing they're going to have to establish, that he's paid a salary, not an hourly wage. And then, they've got to show that his primary duty is management of the enterprise or a certain subdivision of the enterprise. But they're going to have to show that he has discretion with regard to matters of significance. And I think that's going to be another one of those issues. Most fire chiefs do have the ability to make discretionary decisions with regard to matters of significance. Sort of the alternative to that is people who lack that ability. In other words, all they can do is follow policy. Right. And if every time they need to deviate from a policy, they have to check or have it approved by someone, they really don't have that kind of independent discretion. So I think that's going to come down to it. Most fire chiefs in the United States are going to qualify for the executive exemption. Is it possible that someone is out there that doesn't qualify? Yeah. I mean, if your primary job is responding to alarms and there's someone else who's really exercising those managerial responsibilities, then, it's possible.
Right. And he did know one other thing. And this, if true, would be a big fault of the fire company for people to think about. He says, he was never told he was not entitled to overtime. He's not told he's exempt from overtime. And those are important things to put into a job description. We don't hear much about the job description if there's one in writing necessarily, but those, right, are the first steps how you protect yourself. A job description which meets the executive tests, and there's no one factor, right? As there's no one factor that overrides another, but you want to address as many as you can to make sure they're well over the line. And he makes out a pretty good case to start. Who knows what the rest of the facts are? Right.
And we'll see how it all works out. But Bill Macarone has a class on this very issue. Now, it's not specifically on fire chiefs, but it is on officers and whether or not officers qualify for what we refer to as the white collar exemptions. Blue collar employees generally do not qualify for the executive administrative or professional exemption, the EAP exemption or white collar exemption. But
Right.
whether or
Unless they're
not,
like the administrative assistant to the CEO, that type of thing.
yeah, it's got to be something like that. And even then, even if you're going to go under, that sounds like an administrative exemption. You still have to have some sort of discretion with regard to matters of significance. You know, when
Right.
I was a deputy chief in Providence, I had a lot of authority. I was a shift commander, but I couldn't say, hey, you know what? I think I'm going to staff all the trucks with 6 tonight. I don't have that kind of
Right.
discretion. In fact,
Right.
I couldn't go even one above what the minimum policy and really the collective bargaining agreement call for.
And
That's
can,
an that's an
right. And
indication that
conversely, when I was the chief, I could do all of those things, right? And that makes total sense. I could increase staffing, reduce staffing, put on an extra shift, hold people over. I couldn't give them pay
well,
raises or anything like
let me
that.
give you even a better example. Okay. I don't know how many secretaries you have in your office, but could you say, you know what, we're going to go with an extra secretary today?
Yeah.
And I
Yeah.
can too. I can say, well, I'm
Right.
going to have 3 paralegals today instead of 2, or
Right.
whatever it may be.
Right.
So, right, you have that discretion. That is a hallmark of an executive. Someone who all they do is follow policy is not really an executive.
Correct.
Okay.
Right.
And then you get into the issue of, can you leave? If if I'm an executive and I want to go play golf at 2 o'clock in the afternoon, I can leave. And if I want to come in at 10 o'clock in the morning, I can come in at 10 o'clock in the morning. Someone who's working a shift has to be there at 8 and they have to stay till 6 or whatever the time is. And you
Right.
can't leave because you got to wait for somebody else to come in. That's an indication that you're an hourly employee. So again, a lot of different factors I think are going to come in here.
And the
But
fact that he says, if true, my primary duty is to respond to calls, that kind of sounds like they just want someone to be in charge on a scene. And correct me if I'm wrong, that type of power on the scene to run the scene as you want is not the executive power that a court's going to look at necessarily.
No, I mean, I think sometimes courts get confused. There was a court recently that they had a metaphor to the conductor of an orchestra, and they said that a battalion chief is like the conductor of the orchestra, and he's, making everything happen, and that therefore he's an executive. No, I really don't think that's the case. If that's the case, why does he need turnout gear? Why does he have to have a fit test for his SCBA? He's a little bit different than a conductor. Maybe he's the drummer keeping the beat, of things, but I really don't see that metaphor being appropriate. And I think a lot of times you have attorneys that are not that are not firefighters arguing a case in front of a judge who's not a firefighter, and they are sort of able to, with mirrors and stuff, say, well, this is really the thing. But if you don't have discretion with matters of significance, and I think most people who are their job really is to go to fires, really don't have that ability to make those kinds of decisions. They're really not truly what the law expects to be, executives.
And you were at our conference this weekend, which thank you, by the way.
Yeah.
And the FLSA keeps coming up, and people are always surprised, like, FLS what?
Yeah.
Because they're not thinking about it. They're just thinking, everybody thinks, and again, they're thinking old school. Everybody seems to think that, oh, well, if I just call you salary, I have the right to do that. If I just say you're exempt from overtime, I have the right to do that. And think how many questions, you probably get them all the time. We got a ton at, last weekend, but of people just saying, oh, no, they're exempt. Well, that's not the rule. You don't just get to say it and make it true.
Right.
Oh.
No, for sure. And again, Bill Macarone is going to be covering this. I think it's April 18th. It's in 2 weeks, but Bill has got a 3-hour webinar that goes through this. We'll look at the cases. We'll look at most of the cases that we've got it right. They apply the what we call the first responder regulations as part of the analysis. We've got a couple of outlier cases where I really think it was either poor lawyering or poor
Or judging.
poor
Or great
judging.
lawyering on the one hand, if
Um,
you think about it, because they convince
yeah,
somebody that they're right
yeah,
or wrong.
but in terms of a battalion chief being the metaphorical equivalent of a conductor of an orchestra, I'm not buying that. So
No, no. And I've where I don't know where I read this, but I read one of the arguments of look at all the control I have. I can put the equipment on any truck I want. I could determine which truck goes first. I design fire trucks. I do this, I do that. And still, that's not enough, right? Those
yeah,
little things within your wheelhouse of you get to decide where equipment goes on a truck is not the level of
yeah, I get to decide.
administrative.
I get to decide what foot I'm going to put in my bunker pants first. Is that really discretion? I
Right,
mean, seriously, calling for resources and stuff. Now, if they can call for a crane, if I can call up and say, okay, how much for a crane? 2,000 an hour? Yeah, I'll take one for 6 hours. But most chiefs don't have that ability. They can call for
right,
free resources coming in on mutual aid,
right.
but they're not going to be able to. And even if somebody goes hurt, you have discretion on who to call. Well, not really. You're going to get a grievance if you don't call the right person, and you can't
Right.
decide to either understaff or overstaff. Your staffing is set by policy. So
So
I don't
look,
know.
lesson to everybody. This is so, assuming the facts are as he was, this is so common, right?
Mhm.
This scenario is very common. And I caution everybody not to just magically say you're exempt from overtime. That's
Right.
not how it works. You've got to get someone, right? Get a local attorney, whatever, who understands the FLSA. You should definitely go to Curt's, and Bill's class. But when you're designing HR manuals and job descriptions, and you've got to pay attention to these issues if you're going to exempt somebody from overtime. If you want
Yeah.
to pay someone overtime, hey, it's easy, no issue. So,
Yeah. Okay.
okay, let's wow. Just because one crazy story a week is not enough, let's go for number 2. Also not unique, but Jesus. So now we're in Bridgeport, Connecticut, and a firefighter stole drugs from the scene of a suspected drug overdose. And you got to think about it. Now he gets charged ultimately with it's not whatever I was thinking they were going to charge him initially,
Yeah.
but they charge him with evidence tampering, which makes
Right.
sense. You took the evidence, right?
Right.
Which could be a real problem. They could have charged him with a million other things as well.
Yeah, and I think that
Um,
my guess is they couldn't prove that what there was 4 envelopes and the one that he took actually contained drugs, but it certainly was evidence, and
yeah,
he and at least he's accused. Whether he did or not, whether he did take it or not, we don't know. But it certainly would qualify as tampering with evidence at a crime scene, possibly, or at least some sort of a scene that needed to be investigated by police.
yeah, and they allegedly these bags contained cocaine and fentanyl, and he took it from a bedroom in the basement and a walkout bedroom. Anyway, he took it, and one of the things you said at our conference, he said, you said there's always a body cam, and guess what? There was a body cam, so he got caught. If you're going to try to steal something in front of a police officer, I suggest you seriously get some evaluation and help because you're an idiot. If that's truly what happened, if you don't think you're going to get caught on a body cam, you're nuts.
Yeah.
Nonetheless, people's home cameras and anything else that may be around. So
Yeah, I couldn't get there was video news coverage of this, and I couldn't get it to embed, but that also expounds a little bit on the on what happened. But
no,
you know,
that's 2 for crazy for today.
yeah.
Let's go back to a little normal, maybe. Um, let's go to New Jersey. This is a good decision. So this decision, I like it. I like the decision. Here we have an appellate court in New Jersey. They uphold a trial court's decision, which removed a firefighter from a promotional list. And
Mhm.
they did so. The fire department removed him. I guess there were 3 or 4 qualified candidates. They appointed the others, but they removed him. And he said, well, you're doing that to, discriminate or whatever. But he had an extensive disciplinary history.
Mhm.
And based on that disciplinary history, the court said that was a valid reason to remove him from the list. In fact, he had some arrests, and he said, these weren't so remote in time. These were pretty recent. So if you're going to keep doing these things when you're trying to get promoted, you can be removed. Lastly, the court said that even though you had served in a provisional position, the same position just provisionally, doesn't mean that you get the promotion. And in fact, you were removed, they say, from that provisional position. This is just somebody who obviously the department determined had a disciplinary problem. The court says, we're going to yield to you. And I got to tell you, I think this is the normal bent of courts. They want to yield to the employer as long as the employer, comes forward with a valid, convincing reason. I typically think, even though employers lose a lot, especially on the harassment side, when they're doing things like not promoting or not hiring or disciplining, as long as you've got proof of why you're doing it, and in this case, you've got an arrest, or a conviction, it's really easy. I think the courts want to uphold the employers.
Yeah, and I think a lot of times what courts will do, and I apologize for my dog barking, that it's the happiest time of the day. Happiest time of the day. My wife just came home, so the dog has got to, express his happiness. So, but a lot of times what the courts will say is that, you know what, we might differ if we were in the position of, in this case, it was the Civil Service Commission as requested by the employer, but the court might say we would differ. We would do it differently, but they did it for the right reasons, and we're not going to interfere with their discretion. And so, and again, the court didn't say that. The court pretty much seemed to say, look, this person's disciplinary history warranted him being removed. And also his allegation here was that it was over his political affiliation that he was removed, and the court said there's really no evidence of that they had a legitimate reason for removing you.
I will tell you that I get clients all the time. Maybe they lose at trial court, right? And trial court decisions, typically nobody but you ever looks at them. But typically, they're not widely circulated, et cetera. Appellate court decisions are. So normally I tell my clients, are you sure with what they're going to say about you, you want that permanently in an appellate level case? Because look, now his conviction record, very wide known, right? Is the fact that he was a discipline issue, very wide known. You're never getting rid of that now, whereas it could have been sort of buried with the trial court decision. Appellate court decisions, those are circulated and easily findable.
Yeah, for sure.
So. Okay, last one. We're going to Florida. Yay, Florida. And this, we have, again, another kind of basic but interesting issue. It's a lawsuit, not a decision, as opposed to the last one. But he's a firefighter paramedic. He was terminated, allegedly terminated after a cardiac-related event in 23. And he's saying that he's accusing that he was wrongfully terminated based on either being disabled or perceived to be disabled, both whether you have an actual disability, which it sounds like he does, or whether he's perceived as still being disabled from the event. Those both fall under the ADA. And, the guy was rushed to the emergency room. About a week later, he hears that he's removed from the department. Now, if this is true, this is not the way to handle these things. I would not advise that somebody goes to the hospital, especially when it looks like it was line of duty, and and then you remove them. That's not how you do it. You wait to see if a physician tells you they can come back. You hopefully have job performance requirements, and the physician weighs whether you can fulfill the job performance requirements of your position, right? And if you can't, then we'll, either we give you time so you can get healthy, or if the policies or bylaws or CBA or whatever say, okay, you only have so much time. In New York, for example, you get a year. If you're a civil service employee and you can't return to work in a year, we can fire you. So, but to just say you're gone is not the right way to handle it, especially for all we know, if a doctor, could clear you. Now, I will say, we know that 29 CFR 1910, whatever, I think it's 156, says, look, you can't have epilepsy, you can't have seizures, and you can't have a known heart disease or heart condition. and you can't be an interior firefighter if you have one unless your doctor signs off. So that's the important part, unless your doctor signs off. So it's not an automatic. Now, under NFPA 1582, maybe it is.
Well, Brad, I want to take this in a different direction because yesterday, Brad's conference ran from last Thursday till yesterday, and I drove home after we had a nice Q&A yesterday afternoon. But one of the questions we fielded had to do with what do you do when you have a per diem employee who can no longer work? And this fire department, it's the Key Largo Volunteer Fire Department, has had some litigation in the past, and in particular some FLSA related litigation. My guess is that they were per diem. My guess. I didn't say that in the complaint, but my guess is it's per diem. And when you have a per diem employee who can no longer work the shifts, I mean, what are you supposed to do? How long do you keep the position open? You have to find someone else to fill the spots and so on. So I do wonder whether that's going on. Now, they didn't say that he was a full-time employee. The complaint didn't allege that. It just said that he was an employee. So again, I think there's maybe some things that we're missing here. There certainly is a workers' comp aspect to this as well. And if cardiac, I believe in Florida, cardiac issues are going to be falling under that workers' comp umbrella, there could be some, concern about some sort of, workers' comp retaliation if they did in fact fire him. Now, if they didn't in fact fire him, but really he was per diem, he can't work anymore, so we hired someone else, and now they're getting all the hours. We got a different scenario there.
Right.
But
and
recall that question. That was an interesting question yesterday.
It was great. A great question. I wish I almost recorded that whole thing, but now change your paradigm and let's make him a part-time or full-time person where he's got more than 1,250 hours. Now we might bring in FMLA, right, for retaliation. But this all happened within less than a month. February, third week of February to third week of March. That's a very short time to get rid of somebody. And look, if he was part-time, if he was per diem, just don't schedule him for a while until this works out. But I think you got to get a letter from a doctor saying he can or can't return. And if he can return, what are you doing? I don't know. I bet there's a background. We didn't like him anyway. We were waiting for something. Yeah. Who knows?
Yeah, that might very well be. So.
Yep. So happy eclipse to everybody. It's going to look like this, right? It's going to go just about like that.
All right. Well, I guess ours should be starting in about a half hour.
So ours too. Well, if hopefully we keep you out of the legal dark, but if everybody else,
we need that.
We're not any funnier. So, all right. That's it for today.
Well, that's gonna do it for another edition of Fire Law Roundup. We'll see you again next week. Brad, thank you, and it was good seeing you last weekend.